Welcome back, everyone. The Supreme Court of Nigeria has unanimously affirmed that the Freedom of Information Act 2011 applies to all tiers of government, including state institutions. This decision marks a decisive reversal of the 2018 majority ruling by the Court of Appeal, Benin Division, which had controversially held that the FOIA only applies to federal ministries, departments, and agencies. The Apex Court allowed the appeal by affirming the decision of the trial court that the National Assembly has the legislative competence to enact laws on public records and archives. The court noted that the FOIA, enacted to promote transparency, citizen engagement, and accountability in public governance, is binding across the Federation. It emphasized that the principles of openness, accountability, and citizens' rights to access information are not limited to the federal government, but extend to all levels of governance, including states and local governments. Tonight, let's speak with two gentlemen. Mohammed Usman, a lawyer, public affairs analyst. Also joining us on the program is Borno State Commissioner of Information and Security, Professor Tar Usman. Gentlemen, good evening to you. Welcome to Politics Tonight.
Good evening. Thank you. Thank you for having me.
Thank you. Mr. Usman, good evening to you. Can you hear me?
Very much.
All right. So, Prof, let me start with you. It's been 14 years since the Nigerian Freedom of Information Act was passed. This act grants citizens the rights to access public records and information held by government institutions and certain private entities. Could you please help us with a clearer insight into the stipulations of the Freedom of Information Act?
Thank you very much. The Freedom of Information Act is an organic law of the Federation that allows citizens to seek for information from public institutions, information that would normally be under cover, security cover, but as a constitutional right, citizens, including corporate organizations and media organizations, are entitled to freedom of information. So those institutions are allowed by the law, by this law, to seek for those information from the relevant agencies within a specific period. So this is an organic law that is consistent with the Constitution of the Federal Republic of Nigeria. In all democratic countries, freedom of information is part and parcel of the rule books. So Nigeria joined the Committee of Nations that allow for citizens and corporate entities to seek for information on matters of public interest.
All right. And, as clearly stated, there was an objective, which is to promote transparency and accountability by ensuring public access to information, subject to certain exceptions. Now, when you examine better practices of transparency, as it should be, are we there yet? Would you say we've made progress? Would you say we've gotten to a point where MDAs disclose information on their websites without anyone reminding them of doing the appropriate thing?
We are not there yet. We are a young democracy. We are a fledgling democracy, as scholars call us. Therefore, we still have roadblocks, and we still have red tape, bureaucratic red tape, even where the Constitution and the Freedom of Information Act allows for guarantee for individuals and citizens to seek for those information. It is still the case that many entities in this country try as much as possible to block access to information. So we are not there yet, but I think by having the law in itself, it is a good progress, but we have a long way to go.
All right. Mr. Usman, let me come to you. Can you hear me? So it's been 7 years since that Court of Appeal judgment, which held that the FOIA only applies to federal ministries, departments, and agencies. But the Supreme Court has reversed it, indicating that the Freedom of Information Act 2011 applies to all tiers of government, including state institutions. How significant is this?
Is this message for me? I thought you were
for Mr. Usman. Yes, for Mr. Usman, not you, Prof.
Okay, thank you.
All right. Prof, please take that question.
Can you repeat it?
So I said it's been 7 years since the Court of Appeal judgment, which held that the FOIA only applies to federal ministries, departments, and agencies. But now that the Supreme Court has reversed it, indicating that the FOIA applies to all tiers of government, including state institutions. How significant is this?
It is very significant. Nigeria is a federal system where we have the federal center and 36 states. If only the federal government agencies are to comply with the Freedom of Information Act, then it means that a significant fraction of the system are not, liable to comply with this provision. Therefore, this ruling is, a new precedent has been set by this ruling, compelling state governments, 36 state governments, to also comply. It's very significant in the sense that state governments are now duty bound to, concede or to allow, individuals and organizations to seek for information under this act.
But let me also ask you this: what is the implication of this on grassroots development now that the Supreme Court has ruled that the FOIA applies to all tiers of government, including the local government areas, in the face of the same Supreme Court ruling on local government autonomy in promoting transparency at all levels of governance?
Yeah, autonomy is give and take. Autonomy means it gives advantage to local governments to, take decision and to, conceive and implement projects without let or hindrance, without undue interference or supervision from the other tiers. This kind of privilege comes with a responsibility. It means that, on the other hand, local governments are also duty bound to be transparent and to make sure that their business is, can be subjected to due process and can be subjected to this kind of transparency check. So it's a give and take, or I can say two sides of a coin, where the federal government grants a lot of autonomy to local governments, but at the same time, by this legal pronouncement and this verdict, local governments are also duty bound to be transparent. So I think it's all in all is adding quality to our democratic system.
And I'm aware that, while the Act promotes openness, it includes exception for certain types of information, such as national security, ongoing investigations, and personal information. Is there any adverse effects this may have on the long-term effectiveness and implementation of this Act?
Well, the Constitution guarantees privacy, and also the national security protocols also guarantee that security matters are exempted from this kind of, freedom of information check. Even in mature democracies such as United States of America, certain informations of security that have security implications are actually barred from freedom of information until after a certain period of time. That is a statute matter, is consistent with democratic system, and even in mature democracies we have this kind of provision. So in Nigeria too, it is normal, it is okay that certain matters are exempt from this development, especially security matters. If security matters, if ongoing investigation, for example, or if a battle plan of the armed forces, can be subjected to freedom of information even before the battle is held, it means that the adversary will have access to the battle plan and the battle will fail. So it is good, it is normal that certain matters are exempted from this law. And
I also know that public institutions are required to respond to FOI requests within a specific time frame, typically 7 days. So if a public institution refuses to provide, let's say, information, the requester can seek judicial review to compel disclosure. But it looks like the challenges and criticisms are quite enormous. And I want you to talk about the implementation. The Act's implementation has been criticized for facing challenges such as lack of awareness, inadequate training of officials, and the potential for misuse of exceptions. Please kindly speak to these challenges.
Yeah, these are institutional challenges. Yes, lack of awareness is a big problem. It will require, intensive training, consistent training, and also public awareness campaign for even bureaucrats and other relevant stakeholders to comply with the law. But let me emphasize another challenge that is even bigger than the ones that you mentioned, and that is that of record keeping and technology, the use of technology. In the United States of America, freedom of information request can be complied with within a matter of, hours, maximum days. In Nigeria, because of the haphazard nature of our record management, and also because of the lack of use of technology in keeping records, it will mean that for many years to come, freedom of information request will be hampered because we don't have records. We don't have, prompt and efficient, record keeping. We still operate a manual kind of record keeping instead of digital, and it will require manual check before, information can be accessed. So we need technology. That is another challenge, and it will take time before that technology can be mainstreamed in the long term.
And there are concerns about balancing the public's right to information with other legitimate interests, such as privacy and national security, which you have addressed. Another perceived challenge is with some individuals and organizations facing difficulty in accessing information. What would or may change with the Supreme Court judgment?
Supreme Court judgment is constitutionally guaranteed judgment. It's within the ambit of the law. It means that where individuals or organizations refuse to, comply with the freedom of information request, they are liable to be prosecuted or to be held for contempt of court. So it's a good development for our democratic system.
And you now asked that question because the other day I was having a conversation with the Federal Commissioner, Code of Conduct Bureau. The new chairman of the Bureau is coming very hard on public officers who do not declare their assets before starting the functions of his office. He's saying once you don't declare, that's an offense. Your retention for not declaring is immaterial. And I remember that the Federal Commissioner on the March 2024 case where the Court of Appeal in Abuja has held that the Code of Conduct Bureau cannot be compelled by a request made under the Freedom of Information Act to release details in the asset declaration forms completed and submitted to it by public officials. For you, what impact do these kinds of court judgments have on the implementation of the Act and the fight against corruption?
Well, on face value, you can say this development is good for a democratic system, but the devil is in the detail. It's in the implementation that will have problem. With regards to the Court of Conduct, I think it is a question, it's a matter for the Court of Conduct to answer whether they are liable to, reveal information that are held, whether they are statute bad, whether there are, provisions in the Code of Conduct Act that gives them some guarantees to hold on to information until, for example, serving officers complete their tenure. I don't know. It's a matter for the Code of Conduct to answer. But by and large, the Freedom of Information Act and the subsequent court judgment on this matter is an add-on to our democratic system, even though institutions and organizations, both in the public and other domains, may seek to play, obstacle game with it, but it's a good development. And over time, with public awareness, with more court judgments, compelling institutions that have no reason to withhold information to do so, over time, we shall be there as a nation.
And I mean, just before I let you go, two more questions, Prof. Corrupt practices in the justice system often lead to slow and ineffective dispensation of justice. Systemic corruption is like a major obstacle to stability and economic development in Nigeria. And according to estimates, estimates show that in the 60 years since independence, corruption has cost the Nigerian economy more than $550 billion. How do we address the gaps in Nigeria's fight against corruption?
Well, the judicial challenge is one of several challenges of fighting corruption in Nigeria. I think the judicial sector is working very hard to take care of that matter, but we are not there yet. The problem of corruption in Nigeria is hydra-headed. We have obstacles from left, right, and center. We have obstacles, systemic obstacles. We have legal obstacles. We have also behavioral obstacles. All these obstacles are there. And as a nation, Nigeria, if you look at the, the league of corrupt nations, Nigeria is on top. Is occupying a very unenviable position in the league of corrupt nations, simply because we have failed to address the root causes as well as the symptoms of corruption. So it's a national pathology that we have to continue to face. But by and large, the fact that our judicial system is taking steps in order to address these problems. Of recent, we have seen certain development that is very pleasant to hear in the judicial sector, where those who are found wanting are punished and so on. But also the anti-corruption drives of the government, the EFCC is working harder than before. The ICPC is also working very hard. But let me admit that the problem of corruption in Nigeria is still very much with us, is hydra-headed, and it requires more intense campaign and more intense institutional and legal reforms before we can be there.
So quickly, Prof, quickly, I mean, corruption and cost of governance in Nigeria, bringing into cognizance the number of MDAs in the country. As at the last count, Nigeria has over 900 ministries, departments, and agencies, and 541 state-owned corporations. Mr. President has merged some, but the numbers are still high. For some, this has become a drag on the economy. For others, Nigeria is a country with over 200 million people, so we've not exceeded our capacity. But how imperative is this? I mean, minimizing corruption and reduce governance costs in Nigeria to engender development, especially with the Supreme Court's latest judgment on FOIA?
Well, the volume of institutions, MDS, that we have in Nigeria, vis-a-vis the population, I think it's not the volume that matters. It's the quality of governance, the quality of the institutions, and the way they carry out their duties that matter. And you are aware that our audience are aware that, of recent, since from Obasanjo era, there were, attempts to scale down the number of institutions that we have. I think it's a matter of institution building. It's also a matter of getting our institutions right in terms of their mandate and their the way they carry out their duties. So Nigeria has a population of 240 million people. The number of institutions that we have is not that much, but the problem is duplication. There are so many institutions that are carrying out the same functions. Those institutions, I think there was a committee that recommended that those institutions should be scaled down. And even under the Tinubu administration, I think there is an attempt to, merge certain institutions. So, there are ongoing reforms, and by the grace of God, we shall get it right.
All right, great conversation, Prof. Thank you so much for joining us tonight. Professor Tar Usman is the Borno State Commissioner for Information and Security. Thank you so much for your time. We appreciate it.
You're welcome. Thank you so much.
Let's go on a short break, and when we return our attention to the race for 2027 presidency. Please stay with us, everyone.